Yes, I am. Did I send it? If I sent it, I sent it. Then I am
The
also...
question is there authoring a tweet?
There is a difference. Authoring the tweet is
So
writing
that
it.
is the
Sending
question.
it is something
The
else.
question is there a difference between authoring and writing a tweet? So you have to answer whether there is a difference or no difference.
I think the question was, if I remember correctly, my lord, is there a difference between the authorship and the origin of the tweet?
Yes. The answer is yes or no?
Sometimes it is, and sometimes it's not.
Yeah. All right, ma'am. Okay. Well, I'll move on. Do you accept, at least, since you say you don't understand what I'm saying, let's take me out of the picture. You accept that one of the criticisms leveled in this report is exactly that you and the other experts do not differentiate between authorship and sending. Whether it's a valid or not valid criticism, let's put that aside. You accept that that's one of the criticisms.
My lord, may I just please be referred to that in the report?
Okay. Go to, it's in many places, but I'll take you to, just as an example, page 80.
On page 80.
Yes. The first point that he makes is one, authorship. So, you know, are you there, ma'am?
Not yet?
Yes. The first point he makes is that can the state prove that Ms. Zuma-Sambudla personally authored the post even if they were sent from her device? You see that?
I do see that.
Yes. So, again, I know you differ with the expert. So let's put that aside. But you accept that one of the core criticisms he has against your report is that you do not make that differentiation.
That is correct. I can accept that.
And again, just for your own comfort, so that you don't misquote me again, what your Lordship calls the actus reus of the offence, which is the publication, is admitted in this case.
That is correct.
There's no debate about that.
That is correct,
But
my
now
lord.
we're talking about authorship, not the sending or the publication. Okay? All right. Right. Then, sorry, if you can go back to page 44. He deals with your evidence, 44 to 46, my lord. He deals specifically with your evidence, the summary of your mandate. We've dealt with that, you remember?
That is correct, my lord.
How you interpret VCU and Amandla and all that. And he also says that despite acknowledging that some of the footage is from Brazil, you still insist that it was relevant to the current case. That's another criticism. Valid or not valid? Do you remember that?
I do remember that, my lord.
And then if we go to paragraph, page 47, my lord.
Yes, and
He criticizes what he calls interpretive methodology. You would know what that means more than me. You remember that?
That's correct, my lord.
Yes. And among other things, he says that David's translation and interpretation of culturally embedded expressions such as Amandla and Sawubona were undertaken without linguistic expert corroboration. That is true, correct?
That is true, my lord.
So that's a valid criticism.
It's a valid criticism, and I have admitted in court that I'm not a linguist. Yes.
No, I'm fine. And he says, in isiZulu, these are polyvalent expressions whose meaning depends on context, tone, and audience. The word amandla, literally power, is a conventional political slogan historically used as a greeting or affirmation of solidarity. Do you agree with that?
I agree.
Oh,
and I-
let me put it this way. Sorry, ma'am. You said you're not a linguist. That's unfair. You don't dispute that.
I don't dispute that, if I may, my lord.
Of course.
Because the criticism is that he makes, that the professor makes in terms of the interpretive methodology is exactly what I brought to court, is the interpretive methodology. So his criticism is almost supporting what I brought to court. It is, he says, it's undertaken without expert corroboration in isiZulu. These are pluripotent expressions. Those mean depends on the context, the tone, and the audience. And that is exactly what I said, my lord. That is exactly the tone, the context, and how the audience perceived it. So I agree with his criticism, but I don't find it wrong. I don't think his criticism is valid. Thank you so much, my lord.
You told this court that you translated the words on Google, correct?
That's correct, my lord.
Do you know the difference between translating and interpreting?
Yes, I do, my lord.
You did not interpret, you translated.
I translated, and then I did interpret what the English was, and I took what I interpreted it from them, examined the tweet, see if I could see what the message intention was, and then provided that to court. Thank you, my lord.
Is that really possible, madam? Can you interpret a language that you do not know? You can translate it on Google. I can even translate Spanish tomorrow. But can I interpret somebody's expression in Spanish?
No, I was not trying to interpret what was said in Zulu.
Oh, I thought you said you interpreted.
No, I said I interpreted the translation, the English translation, and tried and
I see.
connected to what was said in the message in conjunction with the post, and why, in my opinion, the post was made, and why, in my opinion, media articles were attached to that post.
Thank you, ma'am. We'll deal with that in a moment. He goes then to say, Sawubona, I see you, is a customary greeting signifying recognition of another's humanity. Steinberg's reading of these terms is operational rallying calls, introduces an interpretive leap unsupported by linguistic expertise or pragmatic analysis. Is that a fair criticism?
I don't think it is really fair, because in my search, and it's in my affidavit, to the meaning of the word Sawubona and I see you, I actually relied on a professor in linguistics. It is in my affidavit, please forgive me if I can't remember the name now, who wrote a book on the word and the use of the word and what it means. So I'm quite aware that it means I recognize you as a human. Because I see you, you are. So I speak you into existence. It is a beautiful word, and it has a beautiful meaning. But in the context to what I saw, that is exactly it. I see you. We see what you are doing, and therefore we are recognizing everything you are doing, and we are bringing you into existence. That is why the word Sawubona and
standing there, is it because there is no space, or why are you standing there? Sorry?
Thank you, ma'am. Sorry about that, ma'am. So you're saying it ends there. It has nothing to do with violence, Sawubona.
Again, recognizing and confirming the violence that were taken place. In just prior to the ICU post, there was also a post that said, Siyabonga, thank you for the support. Nothing wrong with that. But if you take it in total, all the tweets and exactly what transpired in that timeline, in that moment of time, a recognition of violence that is on the ground is contributing to further incitement of violence. So the word Sawubona, in its form, in how I interpreted it, said, I see you, I recognize you, we recognize you. And that is exactly the meaning of the word, and that is exactly what the professor says in his report, the word means.
Okay, well, I'll move on again. I put it to you that the professor is saying the exact opposite. He's saying this has nothing to do with violence. Sawubona has nothing to do with violence in any context in the world.
Thank you, that is his opinion, my lord.
All right. Then he says, this approach, your approach, that is, conflicts with ISO IEC, that is the international standard, 27042, hashtag 8.3, which requires investigators to document contextual assumptions when interpreting digital communication. Absent such disclosure, the interpretation risks conflating cultural expression with intent to incite violence, which is exactly what you do. Is that valid criticism?
Had the South African law at this stage in any way compelled compliance to ISO 27073 and in terms of the forensic lens process, which is international standards, the court and might be aware or might not be aware that you know, in complying with these ISOs, you even have to pay for them. It's not something that is freely worldwide recognized. Countries, I suppose, have the choice to comply with these international standards. There is nothing in South African law, no law, that compels the digital forensic process to follow these international standards, not even the law on standards that is used by CSIR. So the criticism, if you want to call it that, by the professor, if this was compelled by law, this would have been a valid criticism, but it's not compelled by law. And I have already explained in my evidence, as I gave, why it was impossible for me to follow those international standards.
Okay.
Thank you, my lord.
Thank you, ma'am. You've answered my question, because I'm not interested in whether it's legal or whatever, or compulsory. I'm just simply confirming that you did not conform with those standards, yes or no?
No, I did not.
All right. So, and then under causation, he says no causal chain is demonstrated between any identified tweet and any specific act of public disorder. The affidavit offers correlation only that the tweets were visible online during the unrest. It provides no geospatial linkage, no evidence that the perpetrators viewed the content, and no proof that any act followed from it. Valid criticism? I
think we've already confirmed that under cross-examination, all the criticism that he puts against this.
Valid.
But again, valid. But we also have to take the context of the specific case into consideration. Thank you.
Thank you. Okay. He says the affidavit, your affidavit, therefore fails to satisfy either the causation in fact or causation in law tests applicable to digital speech offences. Valid, invalid?
I don't. Just give me a moment to formulate my thoughts in terms of that. The core of your question is no, it did not conform.
Yes.
It did not conform.
Yes, that's what he says. Fails means it did not. He says the affidavit fails to satisfy either the causation in fact or causation in law tests applicable to digital speech.
Yeah. So in terms of the second part of your statement, I confirm that it did not comply.
Okay, thank you.
But in my expert opinion, through investigating the tweets and what I have now said many times in court, I believe that there is a causation. So that is my opinion, my lord, which differs from that of the professor. Thank you.
Okay, in the next one, I'll just read the first sentence to save time. He says, under C, page 48, my lord, the affidavit does not provide a verified timeline demonstrating that the post preceded rather than merely commenting on unfolding events. Several of the cited posts appear to coincide with or follow acts of violence already reported in the mainstream media. Valid, invalid?
I don't agree that it doesn't follow a timeline. My entire affidavit is a timeline. It starts from 3 February and it ends at 9 or 10 July, maybe a bit later. So there is a timeline. Is there a separate timeline on an analyst notebook? No, there isn't. But it doesn't say that because I didn't specifically add it, that it doesn't exist. So I don't agree. Can you please just repeat the next part?
Yes, in fairness, I'll repeat it. That's why I read the second sentence, madam. In fact, let me read that only so that we don't get bogged down on timelines. He says several of the cited posts appear to coincide with or follow acts of violence already reported in the mainstream media. And then he says, without precise time zone, normalized metadata and sequencing remains speculative.
Thank you, my lord. Again, a compounded question or a compounded statement. So in terms of it already being reported in the media, that is correct. I did start my investigation in depth on 23 July. So all the events were already over. I think you addressed the court, or the defense addressed the court yesterday on ex post facto evidence. My entire investigation was ex post facto. It was after the fact. And that is why certain conclusions could be made and why I did make certain conclusions. On that, I'll stop. And then in terms of the processes, please help me again.
Okay, yes, no, sorry, let me explain. You misunderstood my question. It was not about your report. He's saying the tweets were reporting on things that had already happened or been in mainstream. Not your report. The tweets.
The tweets by the accused?
Yes. Where that's what he uses. Post hoc ergo propter hoc in Latin. Just means it happened, it is something that had already.
No, I don't agree with that. The tweets were
futuristic.
They were at periods absolutely futuristic, and then at periods in real time. So as things were happening on the ground, the tweets were coming through. There were no ex post facto tweets that I could see because I investigated her account basically from the 3rd of February up to the 10th of July.
That would include the tweets of the events that had happened in Brazil. They were happening in real time.
The tweet was in real time. The tweet was in real time. And again, I need to explain to the court, my evidence is not about video in Brazil. It doesn't matter that it was a fake video. The intention of the message was to show that there is violence. Somebody is standing there with an automatic rifle shooting. And on that, she makes a comment. It's not the video itself that is in contest here. It is the tweet and what the purpose of the tweet was and what the effect of that tweet was in the end. Thank you, my lord.
Okay. Maybe to kill two birds with one stone, since you've mentioned, you're now referring to the Moi Plaza tweet.
I'm not. I thought you were referring to the one where the person from Brazil is shooting.
Okay.
It was not the Moi Plaza tweet.
in your evidence, you said you called that you understand that public violence means violence that happened in public.
That's correct, my lord.
And in your evidence with that Brazilian video, you said that the person was shooting into a crowd.
Yeah,
Remember that?
that is what it seems like on the video, yes.
Well, I put it to you that's just your own invention. There's nothing about a crowd in that video, unless if you want us to play it.
My lord, that was my impression at the time. If I misunderstood, or I didn't see properly, or I didn't look at it properly, the fact is, yeah, we have, I think, 3 or 4 different weapons being shooted, people standing in, it's in the dark, and it would have been purported that it would have been shot in the crowd. The relevance of the video is misunderstood here. It is not about the video and exactly what was happening in that video. It is the violence of that video, of automatic weapons being shot, and then a message that coerced a certain standpoint. That is all I can say, my lord.
Okay, now, there you go again. You're blaming me for, I'm not the one who brought the video here, it's you. Do you understand that?
I do understand
I'm
that.
not the one who said the shooting is in a crowd, it's you.
It is.
Okay.
It is true. It is true. But if, yeah, I don't know how else to put this.
Well, you can put it whichever way. It's either the shooting was in a crowd or it was not in a crowd.
Let's play the video, because at that moment I was under the impression it is in a crowd.
Oh, the TV is off. I'm sorry. Thank you. Do you want to come closer to the screen?
No, I can see from here. I'm good. I'm good.
Is it in a crowd or not in a crowd?
No crowd.
No crowd.
Although, who was singing? Is it a voiceover?
But ma'am, you said yourself that the singing
What I see is not a crowd.
is no crowd.
There's no crowd.
Where did you get the notion that it was in a crowd? Because you wanted it to look like public violence, correct?
No, my lord.
Well, to you, it's not public violence. For public violence, you need a crowd, isn't it, ma'am?
I don't think so.
You don't think so? What is public?
Shooting into the air is, the person is in public, clearly. It's outside, it's in the dark. What would be the consequences of those automatic firearms being shot there? Who would those bullets hit? If there is no crowd in the air, and when they come down?
But this is, we don't...
You see, sir, we are arguing pedantics here.
I'm not arguing with you, ma'am. I'm not arguing, believe me, you are arguing with me. I'm not arguing with you. I'm saying, do you accept or do you not accept that shooting a gun is, let's say it's unlicensed, is illegal. Let's accept that, okay? But for it to be public violence, you have to introduce other people, a crowd, and that's what you did, without any evidence from your head. Any answer?
My lord, I do have an answer,
Yes.
and the answer is basically the following. I cannot remember why I said it wasn't a crowd. It might have been a mistake,
Okay.
but I have to elaborate on that.
Of course.
This is in the public. But we are arguing even a video that apparently comes from Brazil, according to the posters. So yes, there was no crowd. It's clearly there was no crowd. I can see that now. There's lights in the background. It might have been on a hill because it looks quite high. There's singing in the background, which I don't know the origin from. So it's still in a public space.
Okay, ma'am.
So I'm trying to explain why I use the word crowd and trying to explain that this was, in all honesty, my lord, not to prefer charges, not to take this further. I think I have shown my integrity to this court, and if I have said that, the same with the comment about the tribalism. There was no intention to better or to worsen this case. It was merely just to bring the evidence to court, and you know, in defense of myself, I have to say that there were really no intention. I'm not racist. I didn't try and push this case. I didn't. So when the professor makes these comments, it's his opinion. And I can confirm them, and I don't have to confirm them, and it is still my opinion.
No,
Thank you so much.
To do with the professor, I'm telling you that, like the hostel that you imagined, the crowd that you are imagining now.
We have to adjourn 11 o'clock.
My lord, if I can just finish this aspect so that we move on. Ma'am, in fairness to you, you said yesterday that the song that is being sung there, the Members in Siri, sounds like an African language.
Yes,
and I can confirm you are right. Okay? You would also agree that that evidence makes it clear that that song has been superimposed on the Brazilian video.
I suspect so, because you did say that yesterday, so I suspect so now.
Thank you, ma'am.
Thank you, my lord, if I may.
I'm sorry.
I'm sorry.
Yes.
I know that it is a manner of defense. I know that the questions that the defense brings concerning why I would call something a hostel, why I would say it depicts violence, is perhaps because I have let me just think of the words, a agenda. That is not true, my lord. My only agenda here is to bring the truth to the court. And in bringing these videos, there has to be some understanding for the fact that in the 3 months after the July 2020 unrest, I was the sole investigator on 27 of these matters. So sometimes late at night, 2 o'clock at night, when you do an affidavit and you look at something, maybe your opinion are a bit skewed, but the intention thereof was never to mislead the court or to bring evidence that is not real. And I hope that the court can accept that and understand the immense work that I did on this.
It's understood, Ms. Steenbeck.
Thank you so
what
much.
You say.
Ma'am, for what it's worth, even on my side, it's understood. Whatever your intention is between you and your board.
True.
But that your opinion is skewed, I agree with you.
Yeah. Thank you.
So is there a matter for adjournment? Oh, I saw prosecutors.
15 minutes.
No, there's another matter.
Oh, there's another. Oh, sorry.
Okay, it's sorted out. Okay, thank you. Okay, we'll now adjourn for 15 minutes. Court will rise.
Thank you, my lord.
I'm indebted to the court, my lord. Brigadier, we're going to continue again. I'll try again to, if you just answer as I'm asking you, we can move quicker through this. As I said, I'm just wanting to put these things to you in fairness so that you can comment, because if and when this expert testifies, you won't be here. Okay.
Thank you, my lord.
Thank you. We're still on page 48, my lord. Okay, the next section is called context omissions. I won't deal with that because we've dealt with that when we were talking about interpreting versus translating, you remember?
That's correct, my lord.
Yes. Okay, and then the next thing he deals with is what he calls follower attribution. Then he says, the affidavit repeatedly relies on replies and comments from unidentified social media users as evidence of the accused's intent, asserting that these reactions show how her followers, quote-unquote, understood her posts. From a forensic communication standpoint, this is unsustainable. Third-party commentary cannot prove the author's subjective state of mind, nor were those respondents authenticated or linked to any unlawful acts. Such inferential overreach substitutes audience speculation for authorial intent and therefore carries no probative weight. Valid or invalid?
My lord, thank you very much. Certain parts of the comment could be valid, some is not valid at all. Do I need to...
If you wish, ma'am.
If I wish, thank you so much. In terms of the unidentified social media users as evidence of the accused, asserting that these reactions show follows understood a post from a forensic communication standpoint. So I have already testified that this was not a forensic investigation. This was merely an eyewitness investigation from an expert in the field of cybercrime. So no forensic methodology was followed in terms of that. If the professor means a forensic communication standpoint, then that would require an analysis of the communication in a forensic way, which is not within my responsibility or my field of expertise.
Sorry, ma'am. Sorry, I'm sorry. I thought you were finished. Sorry.
Thank you,
sir.
Carry on. Thank you. So this is unsustainable. That is the opinion of the professor. Third-party commentary cannot provide the author's subjective state of mind. I don't agree with this. I think that this entire case is built on her subjective state of mind and the reasoning why she would put certain posts out in the public. Nor were those responses authentic or linked to any unlawful act. I also agree again, the unlawful act here was inciting violence through a social media platform, so it cannot be not linked to any unlawful acts, and such interference overreach substitutes audience speculation for authorial intent and therefore carries no probative weight. I think that is something that needs to be determined by the court, although it is the opinion of the professor. Thank you so much, my lord.
Okay, ma'am. I won't waste time on this, but my lay understanding of what the professor is saying, the expert is saying, I don't know if she is a professor. What the expert is saying is that in simple terms, that you cannot impute the subjective intent of the person who's sending the tweet from the reaction of the commentators. We've established, you and I now, that the commentators might be anywhere in the world, there might be computers, robots, or whatever. In other words, you cannot impute the subjective intent of the sender from the commentary. That's all he's saying, really. If I mean, in my simple understanding, you would at least agree that there's some validity in that. It might not be completely correct. But let me put it this way, ma'am. You cannot necessarily impute the intent of someone from what some computer responds. I mean, from how some computer may respond.
But it wasn't just computer that responded it, and that is why I can't give a direct answer to this. So in terms of not being able to impute what a computer says, yes, I can see the validity of
There's
this.
some validity.
But I have to also then elaborate. This was not a interpretation, or this was not a inferral through what a computer always said. They were actual real human beings.
How do you know
And
that?
because I have already explained to court that it would be impossible for 209 comments to be bots.
Impossible
It would be impossible, sir.
or improbable?
It would be impossible.
Impossible.
It would be impossible.
So how many computers are there in the world?
There's a many computers in the world, my lord, but
That's fine.
you know, a bot wouldn't use language as it is often used in these tweets. That is what I base my finding on. Thank you.
I don't want us to go back there. Now you are telling us that you are not a forensic investigator, but you can understand why the expert might say you are.
I have never said that I'm not a forensic investigator.
Oh, sorry, I thought you just said now.
I said this was not a forensic investigation.
Oh,
This was not a digital forensic investigation.
well, but your affidavit G1, my lord, opens with the following words. I'm a section G1, paragraph 2, my lord. I'm a section commander, digital forensic investigation, DFI. My duties include the national management of digital forensic investigations with the DPCI, that's the Hawks, correct?
That's correct.
Yes. And then you go on about other things. I'm just saying, you forgive someone like me who doesn't know these things. For if that's how you open your affidavit, that what you were doing had some forensic element to it, because that's what you do.
I don't agree. Me stating who I am, what my position and my responsibilities are, does not state specifically that I am a forensic investigator. And I have testified and repeated myself many times that this was not a forensic investigation in terms of forensic standards, and I have provided the reasons for it.
Okay, ma'am. In any event, he's not saying that you are. He's saying that from a forensic communication standpoint, what you are saying is unsustainable. But let's move on. The next one, okay, so the one about the Brazil, we've dealt with that. That's F, misleading content finding. We've dealt with that.
Yeah, I would just want to come back there on that, if we may. So, at this stage, the professor finds that I use misleading content, or I use misleading content, and there's a misleading content finding. I never posted misleading content. I posted the tweets. Yeah. That the tweets contained misleading content was done by the author, not done by me. So I never misled anything. I just posted what I saw and what was there online. So that entire statement to me is invalid.
Okay, I don't think that's what he's saying, but let's move on. He criticizes you for ignoring what he calls the free speech threshold very important in the New South Africa. And we dealt with this. This was the discussion yesterday we had the Constitution, you remember?
That is correct, my lord.
And I had put it to you that even on your version, there was no threat of imminent violence in the sense that it must happen immediately. Do you remember that?
I remember that, and I didn't agree with that.
So in your view, there was something in those tweets that said there must be violence which must be done immediately.
No, there was nothing that said go and burn anything down now, but there were imminent violence.
So if I say you must do something now and then it happens a week later, it's still imminent in your dictionary?
It all depends on the circumstances, my lord.
Generally?
Generally 2 days could be still imminent violence.
3 days?
3 days could be imminent violence. If there is a clear narrative of violence, there is a definite, I don't know what the good English word for that is, but there is electricity in the air. Everybody knows that things are not going to go down well, and there is still somebody that says, go out and commit violence or choose violence. To me, that is still imminent.
Okay, so let's use your term. The electricity and it turns on 7 days later.
That is a twisting of the intention of how I try to explain it, my lord. Anybody who followed the media, whether it was the open media, whether it was anything that was said about the entire situation that the former president found himself in, anybody at that stage knew that there is a distinct possibility that something could go wrong.
Yes.
That's it. Okay. That it was open in the media. A lot of journalists, people on Twitter, everybody said, the day that the president is arrested, there's going to be big trouble in this country. People themselves said there would be war. So that was the narrative of the time.
Thank you, ma'am.
So in terms of imminent danger, if somebody then comes along to that and say, choose violence, in my view, there is an imminent possibility of violence. So in terms of free speech, and that was the question, in terms of free speech, I understand that if there is no imminent violence, that it can't be, you still have free speech. But I think in this specific circumstances, in my opinion, through my investigation, I believe that it just overstepped the bounds of free speech a little.
Yes.
Thank you, my lord.
Thank you, I understand that. It's got nothing to do with your opinion. I'm going to argue that you're just dodging the question. You know very well what imminent means, but we'll move on. Then the next criticism is methodological and evidentiary evaluation. You've already answered that. That's the issue about the international standards.
That is correct, my lord.
Thank you. And then the next criticism is more general. Okay, let's jump to page 51, my lord, paragraph 4.10.6. And that's just a summary of the criticisms. Do you see that?
That's correct.
Okay. And then he says, finally, at 4.10.7 on page 52, the Steinbeck affidavit, while presented under the authority of DPCI's Digital Forensic Investigation Unit, does not constitute scientifically reliable or independent digital forensic evidence. We've already dealt with that. Its interpretive and methodological shortcomings render it incapable of proving authorship, intent, or causation beyond reasonable doubt. In evidentiary terms, it should at best be regarded as contextual commentary, not determinative proof of incitement or terrorism-related activity. Valid, invalid?
Invalid as I do, valid in terms of the digital forensic authorship, intent, causation beyond reasonable grounds, or that I did not follow the digital forensic process. Not valid in terms of that it should not be regarded as, or that it should be regarded as commentary only. Thank you, my lord.
Well, I thought you would have agreed with this. You do agree that in your entire evidence, both in chief and even now, you have said nothing about terrorism, in fairness to you. You've spoken about violence.
I don't think that is correct, my lord. I have often tried to explain how the accused through her publications coerced people to take a specific standpoint, and then to then commit what in this should be the terrorism activity of incitement, that did in the end cause extreme economic destruction and instability. I think in preferring the charges, my investigation did show, I think, rather proper evidence in terms of Section 3 of Boktatara as well, but that unfortunately that evidence was not preferred against the accused. So I used words during my testimony straight out of Boktatara. So yeah.
I see. So one of your recommendations on the charges of terrorism was not adopted by the prosecution.
That is correct, my lord.
So why are you saying unfortunately?
Because I think there was enough evidence for it, but the decision was not mine.
But why is it unfortunate? You are supposed to be a witness who is not taking any sides.
No, I'm not taking any sides.
So why is it unfortunate?
Because there's evidence to it.
In your view?
In my view, yeah.
You disagree with the NPA?
In that aspect, yes. Thank you.
All right. Anyway, that's what the expert is going to say. Ma'am, let me, you and I have had all these exchanges, but I want to answer the following few questions and think about it. I want to maybe to just talk to you person to person. You have said, and I commend you for that, you've brought what one might call the human element to this, in the sense that you say that there was a close bond between father and daughter, correct?
That is correct.
You acknowledge that you are a parent yourself, correct?
That is correct.
Yes. You have a daughter.
I do.
You do. Thanks. And that daughter would not like it if you were to go to prison.
No.
I'm not saying you are.
Surely not, but sometimes I think she might.
I agree. Mine too. But you do know about the special bond, particularly between father and daughters.
Yes, I do understand that.
You do understand, therefore, that of all the 17 cases or whatever the number that you say you were investigating, this particular accused is in a completely different category to the so-called instigators, because, as you're saying, she was making an appeal to basically have her father at home.
My lord, no.
She's
I
the same.
wouldn't place her in a different category. Because from every investigation that I did, the narrative from the start was, and I've testified a bit about this, the narrative from the start was, we don't want the former president to go to prison. We don't agree with his prosecution. This is a political persecution, or this is a unfair handling of the matter, and therefore we don't want to let him go to prison, and if he goes to prison, which then happened, we want to get him out. So in that, there was no difference between what she narrated and what the other, shall we call them instigators? And I don't like the word, but instigators then did. So I can't place her in a separate category for that. I can only place her in a separate category for her support of her father, because I understand that. I understand the support, but not in terms of the narration, that there was no difference.
But
yeah.
that's what I'm saying, and maybe I didn't put the question properly. In what you've said, you've used the we for about 7 times. I'm not talking about we, I'm talking about Duduzile Zuma-Sambudla. I don't know who this we you're talking about. Do you admit that she, not we, fell in a special category because she wanted her daddy at home? Apart from any other instigator who might have had political motives or whatever, she wanted her father to be home. Do you understand that as a parent?
I do understand that as a parent, but I also have to be very objective in that her narration of how to get her father and to keep him out of jail and how to get him home was the same as other instigators. However, I do understand that there was a bigger emotional reason behind it, because he was her father. For her.
Places her in a different category.
In a different category in terms of an instigator and her emotional reasoning behind this, but not in a different category in terms of what she did and what she narrated. Thank you.
Okay. I'm not going to waste more time on this. I'm going to argue again that you fail to just acknowledge even the most obvious facts simply because they don't fit in with the narrative. But let's so for you, she was like any Tom, Dick and Harry.
No, that I just explained it to court. You are trying to force me to make this admission, and I have explained it now twice in front of the court, that I do not place her in a different category, but not because of the emotional part that drove her, because he is her father. In that instance, of course I place her in a different category. She is the daughter to a man who a lot of people respect and a lot of people has honor for. But in terms of what she did and how she used social media to push the issue that was at hand and to get her father out of jail or prevent him from going to jail was exactly the same as the other instigators.
Would your answer be any different if I told you that General Governor, who investigated the matter after you in depth, sat where you are sitting and said that after many attempts, going through bank statements, going through telephone records, because they believed, like you, that she was the same, like all these instigators, they found that there was no evidence connecting her to anyone else. Would that change your mind would that change your answer to understand why she's sitting there alone, not in that case with 60 people, because she was being treated differently, even by the investigators, if you understand what I'm saying? In other words, if I put to you, which I'm not expecting you to know this, that after investigations, after all these attempts, they found that she was not connected to any conspiracy. Would that affect your answer?
No, it wouldn't.
You would still say she's the same as the others.
Please just repeat your question, because
Yeah. Yes,
I
ma'am.
don't think
No.
that's how the question
No, fair enough.
started.
No,
ma'am.
not fair.
Yeah.
I'm sorry. It was a long question. So I'll break it down. Would your answer be any different if I told you that General Governor has confirmed that the state found that she was not part of any common purpose, conspiracy, and so on?
No, it wouldn't change my
Change.
answer.
Okay. Fair enough.
And may I elaborate on why I say that?
Yes, of course, if you want to.
Thank you. Because I believe that in terms of the evidence that I was investigating and the evidence that is in court on my testimony does show the contrary. Thank you so much, my Lord.
All right. And therefore, well, I have to ask you, because this is what we're going to argue. I put it to you that if you take off any partisanship and approach this from, as I was trying to do, from a human point of view, you'd agree with me that it's possible, at least, I won't put it higher than that, that unlike the so-called instigators, it's possible that her only intention was an innocent one, to have her daddy back home. It's possible.
It is possible,
Thank you.
but there is evidence to the contrary.
Yes, but it's possible
It's possible.
in these circumstances. Correct? In other words, I'm sorry, ma'am, I'm saying you wouldn't, if I put that to the court or to anyone, you wouldn't dispute it, given all the circumstances. I don't want to go back to the human daughter. In view of all of that, it's possible that her only intention was to get her father back.
I think what I would like to put to the court is that intent is something that needs to be proven, and that intent cannot rely only on my
No.
surely we all understand
No,
that.
absolutely.
So in my view, in the beginning, her intent was merely to gather support for her father, but there were later tweets that showed that she might have had a different intent when she then did call for violence, and then when she supported the violence. So is it possible that it couldn't be? I suppose this needs to be proven in front of the court what her intent then was. But in what I'm bringing to court, and so you shake your head, I am answering your question, because I am telling you why I say that yes, it's possible. It's possible.
Yes, thank you, ma'am.
Thank you.
No, that's all I'm saying. I'm not sorry if I'm not frustrated. It's because you have answered the question and you have answered it again now, that it's possible. So can we leave it there?
Thank you. We can.
Thank you. So then I'm just going to say this then, and thank you for that honest answer. That I'm going to argue that General Governor was very helpful to the court in conceding the issue of causality and nexus and so on, as I described to you yesterday. I know you don't agree with him, but that's what I'm going to argue.
Yeah, I did not hear his testimony, my lord. So if you put it like that, then I have to take it for what it is. Thank you, my
No,
lord.
fair enough, yes. And I'll also argue that the next witness after that, Ms. Trent, was also helpful to the court, specifically on the issue of unlawfulness, the absence of unlawfulness, that whole debate about Section 16, imminent violence. She considered that there was no tweet that showed imminent violence. You can take my word for that.
Thank you, my lord.
Right. And I'm going to also argue then that your answer, which I appreciate just now, will also be helpful to the court, that it's possible that her only intent was to get her father back.
No. Again, that is not what I said, my
Oh,
lord. I
okay,
didn't say
let's go back.
that her only intent was to get her father back. You are stating it as a fact. I say that you asked me, is there a possibility? Yes, there's a possibility. The
That's
question is, was it probable? And that is what the court needs to determine in terms of intent. So your question was, is there a possibility? Yes, there is. Is it a fact? We haven't determined that. Thank you.
You're the one who's changing my words.
So I'm not
The
changing your
record-
words. I'm
No,
saying to you what you asked
I'm
me.
not arguing with you, ma'am. The reason I asked, if you notice, when I was asking you that question, I was actually reading. Do you remember?
No, I don't remember.
Unlike the so-called instigators, is it possible that her only intention was innocent to have her daddy back home? And you said it's possible.
And I said it's possible,
Thank
but
you.
you didn't allow me to elaborate. So it is possible. I still agree that it is possible. But when you just repeated your question to me now, you stated it as fact, as if there really is no possibility. So, yeah.
You have said initially she wanted to get your father,
That is correct, my lord.
but then you say, as things turned out, only
Yes, yes.
that initial intention changed.
That is correct, my lord.
Well, my lord, that might be what the lordship said. The witness said very clearly to the question which I put to her and I read deliberately. Unlike the so-called instigators, is it possible that her only intention was innocent and to have her baby back home? And she said it's possible. I won't put it more than that. I don't want to debate it with the Thank you, ma'am. That's all I was confirming. Ma'am, I'm not saying anything. If you're saying I'm sorry, that's all I'm saying is what I've just read to you, and you and I have agreed that it's possible.
Thank you, my lord. But again, I didn't change it. I'm not sorry. I just want to reiterate. Oh, sorry.
I'm saying you accused me of having changed it. I said if I did, I'm sorry.
No,
All I want to put
yeah.
to you is what I've just read.
Yeah, thank you, my lord. Just to reiterate, I agree.
During the course of the direction, get attention to
Yes, yes, my lord. Thank you. I will refrain. Thank you.
And all I was saying, actually, I don't know why we're debating, I was complimenting you. I was saying that the one witness dealt with the issue of causality, the other one dealt with the issue of unlawfulness, and you have answered. I won't repeat the question in case there's a misunderstanding. You have answered in relation to intent.
Thank you so
well done.
much.
Thank you very much.
Thank you.
A lot. I just want to round off. My learned friends had said I must give them a warning so that they can prepare the next witness. Yes. Thank you, my lord. Right. Thank you, my lord. Ma'am, yes, I just want to round off a few issues. Thank you for that evidence. Just, and this is now like a more, I'm trying to not to avoid having go through all these videos and tweets. It can be tortuous. But you would agree, wouldn't you, that in fact, yesterday I said that you said that the violence or the violent tweets, so-called, started on the 3rd. But your actual evidence was that it started after the 3rd. I saw that on my notes.
That's correct, my
Is that
lord.
correct?
And I did agree that I did make a date mistake in that. Yeah.
No, ma'am. Listen to me carefully. Yesterday I said to you, you said that it started on the 3rd.
Mm.
Then you said you're making a correction, which you are entitled to do. Yes. So I'm now saying that you agree that you should make a further correction, because you didn't say on the 3rd, you said after the 3rd.
I think the correction that I would like to make is that the call for violence, so the first tweet that spoke of violence, if I could remember correctly from my statement, and if I can just confirm that, was on the 2nd of July.
You can't answer this question without going through your statement.
Yeah, sir, because I'm really confused at this stage with all the dates.
I know. I'm saying, I know you're confused. All I'm saying, ma'am, is not what your statement says. I'm saying your evidence in chief was that the violence started after the 3rd. Yes or no?
Yes, that was.
Thank you. Statement might say something different. I'm not there. I'm not there. Okay. So I'm saying then therefore we should revise the revised version of yesterday, which said on the 3rd to after the 3rd. Correct? You know that on and after are not the same
I
thing?
do, sir.
Okay,
Please, sir. I do.
Thank you.
Okay? What I'm trying to
Then
think here,
think about the answer.
what I'm trying to think here is what I have all said.
Yes.
I did in my evidence in chief say the how can I say the entire feel of the post, the narrative changed. I can't remember whether I said on or after the 3rd, but I rely on what you're saying. So that is indeed correct. And that is fine. I admit that. But I also yesterday further then said, and you might come to that I might have made a date error, and I think it was earlier, and now I'm saying I think it was on the 2nd of July. So you're 100% correct in what I said, that it started after, but I did try and correct that yesterday. So yeah, that's all I can say. So I don't understand. Maybe you should just can explain why you asked me that, because I did try and correct it.
Okay, thank you, ma'am. You don't have to worry about why I'm asking you something. Just answer it truthfully and honestly. I'll break it down. Yesterday, you said in chief the violent tweet started after the 3rd. Correct?
That's what I said yesterday. That's correct.
Logically, that would mean from the 4th onwards, correct?
In my mind, it meant from the 3rd. I cannot remember my words. I'm going to accept that. Logically, it would mean from the 4th onwards.
Take it for granted. I would not mislead the court.
No, I do
If
know.
I do,
I know.
no,
I know. I know.
Okay. Ma'am, I'm not trying to trick you. I just want His Lordship to know what your version is. Do you understand? Yes. So I'm saying, okay, version A was that the violence started after the 3rd. That's from the 4th onwards.
That's correct.
Yes. Version B, which you gave yesterday under cross-examination, was that it started on the 3rd. That's different from version A, correct?
That's correct.
And version C is that it started on the 2nd. That's different from the 4th, 3rd, and 2nd.
That's correct.
Yes. Now, please tell His Lordship which between A, B, and C is your version.
It would then be C, my lord, because that is the last correction I made, and I think yesterday I double-checked the date in my affidavit. So it would be C, my lord.
I see. And do you know when the violence actually started?
From media reports,
No, from whatever.
yeah, around about just after the 7th of July. So it was just after the arrest of the president.
Again, after means after.
Meaning not on that night, not on the 7th. He was early in the morning hours. And I remember seeing the first reports of violence maybe the day after or even the day after that. So it was after the 7th. Yeah, I know from what I read, my lord, and I am not 100% sure whether it was then on the 8th or the 9th. It was definitely on, as to what I read, and this was not during an investigation. This was just reading the newspapers. I think it started like on the 8th, the day after the arrest.
Ma'am, it might be too late for me to give you this advice because we're about to finish. Just answer the question. Do you know when the violence started? No. Yes? No? Or I don't know. It's simple. We don't need all the story. If you know, you know. It's not a crime not to know something. So if you do not know, just tell the court you do not know the answer. You can say, this long thing, it might be the day after, the day before, the midnight, blah, blah, blah. You understand, ma'am?
I do
if I want
understand.
another answer, I'm sorry. If I want another question, I will ask that question. For now, I'm asking you a simple question. Do you, Brigadier Steinbeck, know when the violence started? Yes or no?
Again, I know when it started.
When?
Because the first articles I read about it was the 8th. So I don't know exactly. I don't know all the small little places where there might have been violence and those things. Sir, I need to explain my answer to the court.
Go ahead, ma'am.
Let me say this. When did I first know that there was violence? That was on the 8th of July. That is when I first knew.
You're
Thank
sure
you,
about that?
my lord. I am sure about that.
All right. So the next witness who's going to come after you is going to say it started later than that. Will she be not telling the truth? Any answer?
No, I don't have an answer to that,
Thank you.
my lord.
Thank you very much, ma'am. I have no further questions.
Let's start with that issue at the end of the day. Get proper time. I don't want to take. I want to provide you with a point of reference. Just say before. The incident that I was referring to is the arrest of Council. When did the violence start? Before that or after?
After that, my lord.
Then, I am going to try and keep the explanation as short as possible by lumping together questions. I'll put it to a question about many things in the race, and I will give you as a subject. Right? And then it was put to you about certain possibilities. And one of those things that we're going to use about possibilities is the possibility that all the accused wanted was to bring the daddy home. And we consider that is a possibility. And you will agree with me, but I hope you will agree with me, that it's quite an admirable thing for the doctor to want to father home.
Yes, yes, I do agree.
Now, man, what this case is about, and we all accept that is true, but what this case is about, it's not about the one thing to get, but it's about the method used to try to secure. You understand?
I do understand, my lord.
You understand that? Do you know what the charges against these people?
Broadly, I know that she was charged in terms of incitement to violence, in terms of the Writers' Assemblies Act, and then I know that there is one charge in terms of Boktatara, that also relates to incitement as a terrorist-related activity. So,
Fair enough. So you understand that the core of the charges, the main point of the charges is the fact that there was incitement.
that is correct, my lord.
Amen. When you were asked to investigate and to look for evidence that might corroborate certain allegations, right? Were you specifically asked to look for evidence regarding incitement or involvement in the commission of offense?
Yeah, so I was specifically asked, and I will reiterate, I stated that yesterday already, I was specifically asked to see if I could find any evidence of social media activities by the accused that could be incitement to violence or contravention of Boktatara.
So your investigation then was based on incitement, correct?
It was, my lord.
Now, in order to prove incitement, or in order to demonstrate incitement, would it have been necessary for you to prove actual commission of offense?
No, it wouldn't. My purpose was to bring evidence thereof.
You were asked a lot of questions about did you find anything that shows that the accused or people acted as a result? Was that part of the inquiry?
That was not part of my inquiry, my lord.
Were you required as part of the inquiry to seek or find or locate evidence that shows that the accused actually perpetrated any offense?
No. It was just the purpose of my investigation is to bring that evidence, the tweets, which is the evidence in my part of the investigation, to court, not to
My lord, it's not my duty to assist the state, but unless if my learned friend really wants to ask that question where he has now received an answer which should end this case, then he must rephrase it. Because he asked the witness, was she asked to investigate that the accused perpetrated any offense? And she says no. So if that was his intention, well, then we should all go home.
Ma'am, was it your instruction to look to see whether the accused perpetrated any offense other than incitement to armed violence or terrorism?
Other than those two charges, no, my lord.
That was what my question was. Ma'am, and I'm going to deal with this issue globally, and so as far as you are able to answer, you must refer it to the several times you were asked about this issue. You mentioned in your responses to my colleague's questions, you mentioned the concept subliminal messaging.
That's correct, my lord.
I want you to explain what do you mean by subliminal messaging and how it relates to the findings you made in respect of those tweets that you posted.
Thank you, my lord. So you know, in courses that I did on cyber psychology, it came out very clear that very often social media is used to bring a message across that uses different forms of media to enhance that message or to make that message rather clear. In terms of a subliminal message, in what I saw is that, for instance, the accused would just say something like Amandla. And although that would seem at that stage very interesting and very non-consequential when you look at the word alone, then there would be no problem. But then there comes the subliminal part of showing a protest and then saying Amandla. So the question is still, what was the message that the accused tried to bring across to the wider public? And if you look at the situation at that time and what was going on at that time, then one could make the conclusion that the message in itself and what is subliminally meant with that message could then be a bigger attempt to incitement of violence, because I have said to the court that you cannot take each tweet as an individual. You have to look at the bigger picture to be able to determine that. Thank you, my lord.
Ma'am, when we are dealing with subliminal messaging, right, is it necessary when one wants to use subliminal messaging or send out a confusing message that they must use actual footage of what they want to do, or they could amount to the use of similar types?
No, it could amount to the use of similar type of things, my lord. Maybe in my best explanation, if I'm allowed to, about what a subliminal message really is and what it means is, if I'm sitting in a movie theater and subliminally there is a Coca-Cola advertisement every 5 minutes, then eventually some of the people there are going to say, geez, I really feel like a Coke now. So this is exactly what happened here. It is this constant narrative of it's unfair, it's wrong, commit violence, showing violent images, although it's not even real in sometimes. It's showing these images the whole time. The entire narrative of the Twitter feed was only that. There was nothing else but free Jacob Zuma, support Jacob Zuma, and then later violence, choose violence. Now we see you, so we support. There was nothing else. So in subliminal messaging, if you constantly show the same narrative, you constantly build up to a narrative, then eventually some people will sit there and say, you know what, I feel like a Coke now. And I believe that is exactly what my evidence that I brought to the court showed. Thank you, my lord.
Now, in subliminal messaging, in that context of subliminal messaging, would it matter where the video was made, whether Brazil, China, wherever in the world?
No, because it's not the video itself is not, it's not the crux of the matter. It is, for instance, that an image of violence and shooting guns and protests and people dead on the ground and all these images contributed to the subliminal message to say violence, 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 violence.
In other words, the subliminal message would contribute to the mood of tomorrow, correct?
Yes, indeed, my lord.
My lord, please.
What is the fair interpretation of what the witness are concerning that?
Well, can the evidence come from the witness, not my learned friend? Yes, my lord, was a leading question, my lord, obviously. It's simple. Whenever the evidence comes from him and all the witnesses to say is correct, 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 that's called a leading question.
My lord, the witness gave an answer, a long answer. I summarized to say, perhaps I should have said, are you trying to say, or what do you think? Am I correct in interpreting that way? I said, in other words, and I gave the witness proposition to repeat. I am not putting words in the witness' mouth. I'm confirming, is that what he means? She says, no, we'll probe it further.
So what is the answer that is summarized?
Well, there's so much of interaction between them, and I cannot remember exactly the entire exchange. But it had
proceeded to answer them.
Right, but it was, in my view, I appreciate my
said to help.
I summarized what the witness said. In other words, it was in keeping with the mood of the moment. You said about subliminal messaging that it had to do with the narrative, and I summarized it as that. And she confirmed that. But I'll move on. My Lord, I will argue that in time. Well, let's talk about the comments. I'm also going to argue, as previously, about whether it's negative or whether it is real evidence. We submitted to the spot as real evidence, and we give the different side, and I will give you the real side. Then the responses you were asked to late about it, particularly about bots. I just want you to comment as a person who is involved in that field regarding the availability of bots during 2021 and how much they were in use.
I would not be able to say at this stage exactly how many bots or how prevalent the use of bots were in 2021 per se. But I can say that with the onset of AI, which was rather later, and in the development of artificial intelligence, where your bots were at first rather unsophisticated, as it was in July 2021, to a certain extent it really has increased and has become rather more sophisticated. So bots existed in July 2021. Yes, they did. They were not that sophisticated as they are today. So the bot technology of that time, in the sense that it wasn't artificially intelligence driven, it was still very a manual guy sitting behind his computer creating a bot.
Remember what the respond. Does the bot respond to its own message, or is it programmed to respond to a particular message, and who does that program?
Okay, so it is
When a bot responds, does the bot respond of its own accord, or is it programmed to respond in a particular way, and who does that program?
My lord, thank you. A bot is programmed to respond in a certain way, and it is programmed by the creator of the bot, who is a human. It's a person. Yeah.
I will be careful not to do that in life. Ma'am, I want to discuss, to go through this concept of authorship and sending of a tweet, right? You dealt with it briefly, and I took it further. What exactly is authorship?
Authorship is it has such a broad inference to its meaning, because authorship is first of all the person who has the intellectual property, the person who thinks the thought, then puts it in writing, and then becomes the owner thereof. So that is authorship. It's a combination of your intellectual property and then the right to own that intellectual property. So in short, that's probably the best I can then describe it. But authorship also means then typing the words that you were thinking, and then sending is, in this instance, sending the message. So typing the message and then sending the message. So in order to use the platform, the message needs to be typed, and then there is a button that you say send. Thank you, my lord.
So far as we were asked, and I want you to, we were going to use one of the tweets as an example. I'm not suggesting that that's the one, but let's say a tweet that says a month. Right? I want you to take us through the process that would be involved if two people, one person has authorship and a
My lord, so let's say for instance, this was done from a mobile phone. So what needed to be done is that whoever thought the thought would then have to physically open the Twitter page. They would have to, well, if they weren't online already, they would first have to access the Twitter page by putting in the necessary login credentials, because your Twitter page is protected by a password and a username. So to take it right from the back, you would then have to put in your new username, and you would have to enter your password, and then you would have access to your account. At that stage, no, you're not authoring anything. So now you want to post. So you select the option to make a post. You then type the text. If you want to add a photo or retweet or whatever, you need to then upload that photo onto the platform, and then you would have to say send. So the authorship ends essentially where the message was typed and the photo was uploaded, because that is the entire message. The send starts when you press the button.
So insofar as the submission that was put to you that the accused sent the proofs but might have not altered it, would it be fair to imagine, on the basis of what was put to you, a scenario where somebody typed the message and added a picture and the accused pressed the send button?
I don't suppose it's impossible, but it's really improbable. That would mean two people would sit next to each other. One would be typing, uploading everything, and give the phone and say, "Okay, you send." So, whose is it now? You know, do we go back to the intellectual property of it, or is it now the ownership of the sender? The fact is, this is done on a specific account, to which a specific person has the login credentials and the password, and whatever is posted there by whom is considered in the broader public to be you are the author. This is what you posted.
But even if you're not the author, purely by sending it and also being the owner of the account, what would that be?
That would be you owned it. You owned the data because the data is on your account, so you are the owner thereof.
And insofar as it was alleged that international standards were not maintained or adhered to, right? And you said that you made a comment regarding the fact that you didn't adhere to those standards.
That's correct, my lord.
Having said that, I want you to comment on the integrity, if it is affected at all by the method you use to bring the matter to court.
Thank you so much, my lord. Indeed, I have already stated that I did not follow a digital forensic process that is in accordance to international standard, and I have also explained the legal part thereof, and that it is not compelled in terms of South African law. The thing that a digital forensic investigation helps a digital forensic investigator of is that it then, through the digital forensic software that is used, automatically authenticates the originality as well as the integrity of the evidence through, as I explained in my evidence in chief, SHA, hash and different encodement to show that the integrity of the evidence is intact. Now, as I did not have the digital forensic software that could do that for an online investigation at that stage, and because I already mentioned about the time that it would take to get a warrant would defy the purpose of this search, but it boils down to the fact that the police did not have such digital forensic software at that stage. And then there was also the threat of myself then contravening the ECT Act by gaining unauthorized access to data. So, in terms of a digital forensic process, I could not prove the integrity of the evidence in my affidavit, but only in terms of that, because that process was not followed. When I made the screen grabs, I then immediately, a screen grab is a photo, and the metadata in the screen grab shows exactly when this photo was taken, and it shows exactly its path where I saved it. And that I did do. So where I was faced with these circumstances, I brought the best possible way, or I used the best possible way to assure the integrity of the evidence that I took pictures of, which is in my affidavit. And that is still available on my computer. That is why I did not play anything from my files on my computer, because those files still show that this was downloaded either on the 23rd or the 24th of July 2023, and that it was never opened again. So that is the exact photo that I took. And in terms of that, my evidence is, its integrity is above reproach, my lord. And then, of course, as I explained in terms of the Electronic Evidence Act, it is not only, it very clearly prescribes that there's no, it doesn't always have to be a reliance on an electronic process or a forensic process. It can also be that evidence can also be admitted by a witness. Thank you, my lord.
The integrity of the evidence that you brought is nothing challenging. I just wanted to, is the evidence that you brought any less reliable than had you used the international standard?
No, my lord, because because I could show the original evidence in court straight from the online source. Thank you, my lord.
When it was suggested to you regarding comments that support or indicated support.
Sorry. Thank you, my lord. Yeah, again, I don't apologize. I don't want to interrupt my learned friend, but you know, this record might go to other places. Maybe my learned friend wants to change his statement that the integrity of the process has not been challenged, because I put to the witness many statements that come from the other expert which do exactly that. So maybe my learned friend, which talked about the whole thing about ex post facto and trends and authentication and difference between authorship and whatever. I just don't want to be accused of having kept quiet and then I have to live with the misleading question.
But not because we have a provisional thing before you not by law. And questions were put to the witness by my colleague based on the provisional thing. So until that witness testifies, this is a non-issue, but I will do this. The witness will give me the quick break.
Oh, yes.
And we take it and then
My lord, yes, if the witness wants a break, I have no problem, but my objection stands. Yes, I'm told, my lord. Yes, the objection stands. We'll deal with it when we get back.
Thank you, my lord.
Which one is giving you a problem? Because this one is perfect. This one is perfect. So where's the when I'm going to
It won't even take 1 minute.
There's something omitted.
Yeah.
Mr. Gangai.
Mr. Kanga.
Mr. Gangai, he may put what he may put what he omitted. You may
React.
the man.
All right.
There is no prejudice to the state.
Yes, you may.
Yes, ma'am. Well, since I'm on my feet, let me ask you this. You said you did 12, I think, or 17, is it 17? Yeah, investigations regarding this kind of
Yeah,
thing.
it was 27, my lord.
Yes. Yeah. In how many did you do a so-called negative?
Maybe 13 of them.
So in the other 7, is that where the 17 comes?
Yeah, I think it was
17.
17 that was positive and 13 that was negative.
Now, all right, the issue that I omitted, and I apologize to put to you, and again, I don't expect us to debate it, but in fairness, I must put it to you, is that one of the criticisms of the expert report that we referred to is that you and your other colleagues did not take into account the outcomes of the South African Human Rights Commission report, independent report. You remember that?
That is correct.
You are aware that report found, among other things, that there was no connection between the violence and the incarceration of former President Zuma.
Yes, that is correct.
You're aware of that? Yes. And but that finding, whether it's right or wrong, is another issue. That finding is not taken into account in your report. That was the criticism. Is it a valid criticism or not?
I think in the independency of my investigation, it is not valid. Thank you, my lord.
So it would have made no difference.
No, it would not have made
Thank
any
you.
difference under these circumstances, as I did find evidence to bring to court. Thank you, my lord.
Thank you, my lord.
Thank you. Mary is a mind on that last
I
point.
do.
Thank you, Ms. Yes, Campbell. You may step down and excused.
Thank you so much, my lord. Much appreciated. Thank you.
Will you take the long term now to do now? I can place on the spot that the next is already at call. I have made available to her the expert report into the H that she will, I have no doubt, be called upon, comment upon. And I have told her to try to get as ready as possible on it by 2 o'clock.
So we can start 2 o'clock.
I would advise your lordship if there are any delays to the registrar, but at this stage, she's been very good.
But, yes, my lord. Well, it's probably, given past experience, it's unlikely that she'll be cross-examined today if we're going to have the customary 5 hours. But if so, I think we can still start at 2, my lord.
My lord, I will make that decision after I've spoken to my witness. I might want to give her evidence before she's cross-examined on the report on certain aspects of it.
That's good, please.
All I can say is that the court will adjourn until 2 o'clock.
Thank you. I'm going to walk into the It's not one. So the behind the camera.
But sometimes we are late, yeah. Yeah, no, it's fine. It's next card.
I'm going very sober. Yeah.
Emma Sadler.
It's Emma Georgina Sadler. I do not. I do. I do, so help me God.
Thank you. Ms. Sadler, please state your experience and academic qualifications for the record.
Thank you. My experience is primarily in law, with a particular focus on the law as it relates to social media. So I started out my career studying law. I did a BA, then an LLB at the University of Witwatersrand, and then a master's in media law, communications and information technology at the London School of Economics. I worked in the media litigation department of the law firm Webber Wentzel for a period of 5 years. In April 2013, I started a company based in Johannesburg. It's called the Digital Law Company. So when I started it, I took myself off the practicing role of attorneys.
You can just slow down because we are writing.
Absolutely, my lord. Apologies.
Yes, you work for a media
I
firm
work,
at Webber Wentzel, yes?
yes, at Webber Wentzel in the media law department for a period of 5 years. And then in April 2013, I started my own legal consultancy called the Digital Law Company. It was at that stage, my lord, that I became a non-practicing attorney. And moved direction into consulting, thought leadership, and education. So a lot of what we do, my lord, at the Digital Law Company is giving educational talks to schools, and I myself have addressed over 1 million students around the world. On the kinds of laws that apply to content on social media. I also speak at companies and conferences about the legal, disciplinary, and reputational risks of social media. So, my lord, my areas of expertise lie predominantly in defamation, privacy, hate speech, cyberbullying and harassment, image-based violence, particularly through the use of artificial intelligence. So more and more I'm focusing on AI and law, but in particular when it comes to image-based violence. and then all of the issues relating to children and their online worlds. Gaming, addiction, mental health concerns, online safety. As part of this educational calling, I've written a number of books. I've written 3 books published by Penguin Random House. The first was published in September 2014, and it's called Don't Film Yourself Having Sex and Other Legal Advice for the Age of Social Media. The second one, published by Penguin Random House, was Selfies, Sex and Smartphones, a Teenager's Online Survival Guide. And the third, which was this year, is called How Not to Mess Up Online. In addition to those books, I was a contributor to the LexisNexis publication called Communications Law, primarily written by Dario Milo and Pamela Stein. I also drafted the social media law section of the LexisNexis textbook called Communications Law. And I'm in the process of updating, with Dario Milo and other authors, the Media Law Handbook published by LexisNexis. I've been involved in making submissions to Parliament on a number of different new laws relating to social media and media law in general. But primarily, my lord, what I do is act as a first responder when things go wrong on social media, whether it's for companies or children or schools or parents. I have appeared as an expert witness in the Equality Court, sitting in the High Court, many, many times in the CCMA, and in a criminal matter relating to social media in the Magistrates' Court. I'm frequently asked by clients to look at digital content and prepare opinions on what should be done about that content. Primarily through a legal lens. I was involved in a very high-profile case this year where, acting on behalf of children who were affected by content online, on Instagram and WhatsApp channels, I successfully took Meta to court. And it was one of the first cases internationally where an international tech company has consented to the jurisdiction of a foreign country.
Thank you. Right. Now, ma'am, as far as this case that we're busy with is concerned, I want you to place on record how you became involved, what was the scope of your involvement.
Just want to grab my notes on the chronology. Thank you. My Lord, in October 2022, I received an email from Colonel Nazo of the DPCI requesting that I prepare a memorandum about whether, and I have the email here, with regards to DZS, I quote from the email, my Lord. At that stage, I did not know who DZS was. I was told the abbreviation would be explained later. If I could look at her Twitter and answer the question of whether she could be seen as an instigator or inciter. If my answer was to be yes, then could I elaborate? Also in that email, I was asked if there was any policy or legislation which deals with Twitter and WhatsApp on social media. I was also asked if there was a law dealing with incitement on social media, and if so, what the terms of prosecuting would be. I was also asked what a Twitter user's responsibility would be regarding words used. And finally, if there was any case law locally or internationally that could be used as reference for any prosecution.
Thank you, my Lord. My Lord, yes, just one, whatever the witness is written from, can we be given a copy?
The email.
Not necessarily now.
The
but
email.
Yes.
I will attend to it, my lord.
in due course, as the court pleases.
I replied to the email saying that I would be able to assist in October 2022. In January 2023, I had a meeting with representatives of the DPCI at my home office in Johannesburg. A few months later, in May of that year, 2023, there was an additional meeting at my house where I received a USB which contained the WhatsApp chats of 3 different WhatsApp groups. So I was asked by the DPCI to prepare 2 separate memorandums on 2 different issues. The one related to the WhatsApp groups, in particular liability for content circulated on WhatsApp groups. And the second memorandum is what became part of the docket.
Of the docket of the case we're busy with now.
Correct. I finalized my memorandum on this matter in September of 2023. So I note, my lord, this memorandum was not prepared as an expert witness statement, but as a memorandum to a client about whether or not I believed there was a case to answer.
It was, as you say, included in the case docket as your affidavit.
It wasn't even signed as an affidavit. It was a memorandum, a legal memorandum to a client, which, my lord, is something I do very frequently in my business. Indeed, last week I did 2 for corporates wanting to know what to do with content affecting them on social media.
You have had access to it in preparation for your evidence today.
I have.
And do you confirm the correctness of the content of it?
I do.
And it is signed by you.
It was.
Lord, may I hand in the memorandum as it is being referred to by Emma Sadler, dated 27 September 2023, as Exhibit J. Exhibit J in this matter.
Exhibit J.
J. Ma'am, you are in possession of a copy of your statement. Can you just confirm that that is your document?
That is my document.
My lord, I don't mean to interrupt. I'm assuming my learned friend deliberately jumping aye. Or,
I deliberately jump I because
yeah,
we have
because
one.
it's difficult to, because sometimes one and I look the same.
No, I deliberately jumped I, my lord, so that because we already have one as a real thing.
Thank you.
Thank you, ma'am. We are going to use the document as a reference to your evidence. My colleague for the defense is already in possession of a copy. Ma'am, I want you to...
Sorry, my lord, yes, I confirm, no objection.
I just want you, we have quite a background about Twitter and tweets and what they are, and I think we'll deal with that only as far as it becomes necessary for the purposes of your evidence. I want you to, however, place on record the methodology that you used and the type of exercise that you did in order to come to the conclusions that you've come to in your memorandum.
Thank you. My lord, I really went into this matter totally cold for two reasons. The first was during the period which forms the focus of this case, I was very, very ill with COVID and I was in hospital, which meant I wasn't following the content in real time, which is unusual for me because I spend a huge amount of my life keeping up to date and following what's going on social media, particularly in South Africa. The second reason is that I wasn't provided any information, any documentation, I was simply asked, look at the content of the accused, which was all publicly available and remains publicly available, except for one tweet, which I'm sure we'll discuss, and form an opinion on whether or not there was a case to answer. So the first thing I did, which is the same modus operandi I follow in all of my opinion work, is to look at the content, to look at the account, to get a feel for the kind of account we're dealing with. So I started by doing an analysis of the accused's Twitter account, at the time, and I'm at paragraph 6.1 of my memorandum, if you'd like to follow.
That is on page 8 of the memorandum.
Page 8 of the report, of the memorandum. So the first things I saw was that the name of the account was at the time Duduzile Zuma-Sambudla. The Twitter handle was at @dzuma-sambudla, and the account was publicly available. My lord, there is a way on Twitter to lock an account or to make it private, in which case only approved followers can see your content. That was not the case here. It was a publicly available account. At the time of the assessment, the account had over 260,000 followers. I note that's at the time I compiled my memorandum, not at the time the tweets which we're going to discuss were published.
So that would be some point after January 2023.
Correct.
Do you recall an exact time date?
I looked at it twice. The first time I looked at the account was in, I want to say June 2023. If you go to paragraph 7 of my memorandum on page 19, I explain that all screenshots in the report, in the memorandum, were captured by me on the 28th of June 2023.
It's paragraph
And
7.1.
Paragraph 7.1, and on the 26th of September 2023. I note that in preparation for the trial, I looked at the account again. The name of the account is now Honorable Duduzile Zuma-Sambudla, and the accused now has approximately 365,000 followers. During my assessment and drafting of the memorandum, the accused followed 11 accounts. Those 11 accounts are screenshot on page 8 of my memorandum. I note that now the accused follows only 7 accounts. My Lord, if I can take you to paragraph 6.3, I've made the point already that the account is public, but perhaps I haven't made the point that you don't need to have a Twitter account or to be following an account in order to access publicly available tweets. Any person with an internet connection has access to that content.
Regarding the methodology that you used?
So, having assessed initially the kind of account we were dealing with, which is a big scale, on the followers at the time of my report, which was 260,000 followers, now 365,000 followers, I got a feel for the kind of content that the accused posted. And I picked up various themes. The first and most overwhelming theme was the volume of content posted by the accused in support of her father, former President Jacob Zuma. I have included samples of these kinds of posts from page 9 to page 15 of my memorandum. Would you like me to read those tweets?
I was going to suggest that we skip over those pages. We've dealt with that evidence, and it is common cause that the accused is very supportive of the party.
So if we skip to paragraph 6.6 of my memorandum on page 16, I note some other prolific themes in the accused's Twitter account. Firstly, her apparent hatred of President Cyril Ramaphosa. Frequently depicting him as a caricatured clown. I quote, a proxy leader for white monopoly capital. And an apartheid figurehead. I have included samples of those kinds of posts from page 16 to page 19 of my report.
The period of reference, or the main period of reference, as per the instructions you were given, was for July 2021, correct?
Correct. So, having assessed the nature of the account and the primary themes on the account, I then focused my attention on the tweets posted by the accused in July 2021. And at paragraph 7 of my memorandum on page 19, I start my assessment of that period. I note at the outset that the accused Twitter feed during this time included encouragement, jubilation, and celebration of the unrest that had South Africa on its knees during that period. Again, thematically, most of the tweets in this period included the phrase, "We see you," usually coupled with the word amandla, many exclamation marks, and multiple fist pump emojis. I also note at the outset that some of the videos which were attached to the tweets, what we would call the media, attached to the tweets, which purported to be about contemporaneous violence and unrest, were actually old videos which had been repurposed to create the impression that the protests were happening contemporaneously and in support of the accused's father, Jacob Zuma. I then go on in my memorandum to capture a screenshot of a tweet posted on the 1st of July, which shows an unidentified person shooting an automatic rifle into the night sky. Which included a song in isiZulu, and a tweet posted in isiZulu, which I believe translates as "shooters out in KwaZulu, ... we are waiting, hashtag in Kandla."
That is at paragraph 7.5 of your memorandum.
7.5 and 7.6.
7.5 and 6, yes. Now, ma'am, just so that we don't have to go over everything again. You were working out of the Twitter account itself, correct?
Correct.
And you have made or drawn electronic versions of that, is that correct?
Correct.
And you have put those onto memory sticks for the assistance of the court, is that correct?
Correct. In drafting the memorandum, I used a function on my computer called the snipping tool to take screenshots of the content available for the purposes of putting that content in the report. In preparation for today, my lord, I created a screen record of those tweets, including the videos attached to those tweets being played chronologically. In case it may assist the court.
You have made copies of that?
I have made copies. They're on USBs.
My lord, may I hand in the Exhibit 3? I'm making available a copy to counsel for the defense also. And this is of what has been prepared, my lord, for the presentation of the evidence in court. The witness will explain what it is as we go, but it's the same videos that we've been watching up to now.
My Lord, unfortunately this is being presented for the first time, but if my learned friend gives us assurance that there's nothing new in it in terms of the videos, then I'll have no objection. But if it arises that there's something new, my Lord.
So you have not seen it?
I have not seen it. Not in this format, but if it's the same videos that we've been seeing, then I'll just take my learned friend's word.
My Lord, it is largely the same, but I believe that this witness dealt with some videos other than what the previous witnesses did, and that will be dealt with during the evidence. But I think it's probably 2 or 3 videos that we put.
Yes, my Lord, I have no objection. If that is correct, it's because I do know from the report that there are 1 or 2 videos that will be presented for the first time. For the rest, it's what the other 2 witnesses dealt with. So if it's of 2 or 3, then we can live with that, my Lord.
Well, I can assure you it is not many videos, and it has been prepared this way for the specific purpose of not taking too long, as we did with the previous witnesses, where the witness can go through it much faster this way than we did with previous witnesses. Perhaps the witness can explain exactly.
Then Mr. Mbofu said to take your words that if it's the same video that they have seen before he has been programmed, and so you can proceed along those lines.
My Lord, as I said, it's largely the same, but there may be 1 or 2 that are new.
If I may, my Lord, there are 3 files on the USB. One shows all of the tweets of the 9th of July only, as they still appear online. I captured the video yesterday. The second folder has the 2 tweets of the 10th of July, which all appear in my report. There is 1 new tweet in a separate folder, which was posted by the accused in January this year on the theme of "We See You."
All what I can say, Mr. Prosecutor, counsel, is that any evidence that is brought before court, it will not be by ambush. We will have liaised with everybody, will have been aware at our counsel that this nature of evidence will be brought. That will save a lot of time rather than them encountering new evidence in this court and start another unwarranted argument. So if
as I said, my Lord, I
to share that kind of information, so you may just explain now.
My Lord, as I said, the evidence on the videos are largely what has already been viewed in court, and there are a few new ones that the witness will explain. For example, the January 23 one, January 24 one, which the witness will deal with as she testifies.
My Lord, your Lordship is quite correct. Well, this is not the usual way to run a trial. But, my Lord, for the sake of progress, as I said earlier, if something does arise, as your Lordship says, that looks like an ambush, then we will point it out at the time. For now, my Lord, for the sake of progress, we would not seek an adjournment or make a formal objection. But my learned friend knows better that if there's any evidence that was generated last night, the first thing he should have done was to alert me this morning and give it to me. He can't just do it now when the witness is here. But, my Lord, all be that as it may, the evidence can continue. So we just want to place that on record.
Thank you, Mr. Mbofu.
My Lord, the court is my witness that I've been in court since 9 a.m. until we adjourned for lunch. There was not much opportunity for me to engage with the witness before we adjourned.
You may proceed, Mr.
Thank you. Ma'am, will you...
So before then I must know what is this?
Is Exhibit 3.
What is it?
It is a compilation of the electronic data that was used by this witness. in the compilation of a report as well as preparation for the trial.
And then the memory state is admitted as exhibit.
Exhibit 3.
May proceed,
Thank you, ma'am. You may now proceed from, as you were describing to us, paragraph 7.5, right? I will try to disturb you as little as possible as you go through the evidence because it's a repetition largely, and if there's something that I specifically want you to comment on, I will let you know.
Thank you. Thank you, my lord. So, just to confirm, the electronic evidence is just the electronic evidence of what has already been presented, so we didn't have to rely on internet connections to find the live content. All of the tweets...
May proceed because when you were not here about what was presented, so just focus on what is before you.
Thank you.
What was presented before you came here, they will know better.
Okay, thank you. So, if we go back...
Yes, my lord. I'm sorry. Yes, my lord. Yeah, as I said, my lord, we will assess the situation. My concern is that any new electronic evidence at this stage will obviously not have been presented to the expert. So, but again, if there's nothing dramatic about this, then it might not arise. But if it does, we obviously reserve the right to present that evidence to the expert, and he may want to do a supplementary or whatever. But
so you have no objection if we proceed?
Subject to the right to intervene if there's an ambush, and also to get our expert to view any evidence.
Thank you. May proceed, Mr.
As per, please, my lord. Ms. Sadler, can you proceed with your evidence?
Thank you. So I was at paragraph 7.7, which deals with, at this stage, still background, because my focus really was on the tweets posted on the 9th and 10th of July. But it relates to the tweet captured in paragraph 7.5. And I'd just like to note that according to the fact-checking organization Africa Check, the video attached to the tweet in paragraph 7.5 was actually a video taken from the 7th of December 2019 by a Spanish-language Venezuelan news outfit. So the video was taken, according to Africa Check, in Venezuela in 2019, and the audio was manipulated.
What do you mean manipulated, ma'am?
It means that if you go back to the original video as published on the Sumarium website, it contains a Spanish speaker that audio was changed. I note that the tweet is still available, and it's at the URL available in footnote 5 on page 21.
Were you able to determine where the manipulation had taken place?
No.
None of it can be attributed to the accused, correct?
No. The accused published the video. The accused published the video.
Yeah, on the basis that you mentioned the manipulation, I wanted it to be clear that we are not attributing the manipulation to the accused.
No.
Thank you. May I proceed?
On the 8th of July, a particular hashtag started being used. Now, bear in mind, just before midnight, the day before, former President Jacob Zuma had turned himself in to the escort police station. And the first tweet I could find using the hashtag #FreeJacobZuma hashtag was posted just before 2 o'clock in the morning, so a few hours after former President Jacob Zuma had arrived at the escort police station. If we jump to paragraph 7.13 on page 22, I include a tweet posted by Carl Niehaus. At 10:34 on the 8th of July, 2021.
7.13.
The tweet contained a picture of Jacob Zuma and simply said, #FreeJacobZuma. Later that day at 16:38, a Twitter account with the handle @AfricanSoil, who at the time had approximately 75,000 followers, published a video of a truck dumping a huge pile of rubbish onto a road at an undisclosed location, with the tweet at the top of page 23, the continuation of paragraph 7.15. The tweet stated, the #FreeJacobZuma demonstrations have started, ...
Ma'am, before you proceed with that, just explain to us the use of a hashtag and with the reference to the #FreeJacobs.
Thank you. My lord, a hashtag provides a very specific function on social media. If you put a hashtag in front of a word or a phrase or a combination of words, that hashtag becomes a hyperlink which takes you to a place where every single person who's used that same hashtag, their content appears. So, my lord, if you're at a wedding and you're told this is the hashtag of the wedding, then every person posting pictures or content about that event who include that hashtag, if you clicked on that hashtag, it would take you to where all of the content posted by all of those people is collated in a list. So it's a way for often people who are unknown to each other to contribute to a conversation about the same topic. Some famous examples in South Africa, particularly when it comes to social activism, was the #AmINext campaign, which was largely about gender-based violence and a continuation of the hashtag #MeToo movement internationally. But it meant anybody who told their story and included the hashtag #AmINext could click on it and it would take you to everybody else's content who's used that same hashtag. My Lord, it has a further function, which is that on Twitter, now known as X, where many people are using the same hashtag, it starts what we call trending. So at any given time, you can see what the top hashtags are being used in online discourse.
Just a moment. I'll adjourn for just 5 minutes.
I didn't want to do so now because of I didn't want No, maybe. Yeah, you are right. You are right. Hey guys, I hope it's not the length of the evidence lodged that is confusing.
Thank you. So we got as far as the end of paragraph 7.15. On page 23, if I take you, my Lord, to paragraph 7.16, where the accused tweeted, "Just spoke at President J.G. Zuma," which was former President Zuma's Twitter handle, "en route, and he is still in high spirits. He said that he hopes they still have his same overalls from Robben Island. And we laughed hard at that. At least he won't struggle with Afrikaans this time round. We salute Dad, exclamation mark, Amandla, exclamation mark. And I've included a screenshot of that tweet, which includes a picture of former President Jacob Zuma with his fist raised in the air in a fist pump.
That is on page 24.
At the top of page 24, I omitted to include that there were 3 fist pump emojis and 3 exclamation marks at the end of that tweet.
What is the significance, ma'am, whilst we're on the subject of you wanting to particularly mention the fist pump and the exclamation mark?
So, my lord, when I tell people at dinner parties that I'm very interested in emoji law, they laugh at me and say that that's not such a thing. But I can tell you that I do a lot of work around emojis, because what an emoji is really just another way to communicate. Firstly, it is in itself communication. For example, my 4-year-old can send me a message entirely in emojis before he can read and write. So in itself, it has the value of being able to communicate meaning. Even more important than that is that what an emoji does is that it often acts as a tone identifier. So, for example, if I say to somebody, I'm going to kill you, that's a very different message to a message that says, I'm going to kill you, with 25 laughing emojis. So an emoji can be a very useful identifier in terms of tone as to how I say something. When we're dealing with content on social media, it's very often a toneless place. So emojis help with that. In this particular example, on page 24, we see former President Jacob Zuma himself with his hand raised in a raised fist pump. What those emojis do is it's a textual representation of that action. I have, my lord, further on in my report, prepared a section on emojis, and in particular a section on the raised fist emoji. That appears on page 67 of my report.
We will deal with it in more detail as we proceed. Go on, ma'am.
Before we go further, I'd like to take you, my lord, to the numbers and figures at the bottom of that screenshot, which appears on page 24. You'll see there are 5 different icons. The first looks like a message bubble. Now what that shows, my lord, is how many people have commented in reply to this tweet. Just this tweet. So that's the message bubble. The next one along has 2 arrows. That's how many people retweeted that particular tweet. If I retweet something, that tweet appears as it was to all of my followers. So the retweet function can create exponential reach. You can retweet it in a vacuum, or you can do what we call quote tweet it, which is where you share the tweet, but with some commentary, your personal commentary above it. The next icon along is the heart. That's how many people have favorited the tweet. And you'll see the numbers there are big. We're dealing with over 1,000 comments, over 2,500 retweets, and nearly 13,000 likes. The fourth icon at the bottom there, my lord, has what appears to be a graph. Now, after billionaire Elon Musk bought Twitter and rebranded it as X, that graph data, which is how many impressions a particular post has received. So if I've tweeted something and it's seen by 70,000 people, sometimes because they're my followers, sometimes because somebody else has retweeted it, it'll tell me how many people has seen that particular tweet. In July 2021, that data wasn't available to us. It is now. So, for example, the current pinned tweet, which is the tweet that is at the top of the accused's Twitter account as it appears, has well over 600,000 impressions. 600,000 people have seen that tweet. That's data that's available to us now. As I say, during the period July 2021, that data was not available. So if I carry on with my memorandum at paragraph 7.17, I make the observation that for me this was one of the most important tweets from the accused, because it sets the stage for her speaking almost on her father's behalf, almost as a spokesperson. Obviously, an incarcerated person does not have access to social media. And so my observation was that she was almost a spokesperson for him at that time. And then, my lord, we get on to the tweets which really are in question, which were posted on the 9th of July. And that forms really the bulk of my report, from page 25 to 50. And it was these tweets that I've made the electronic version of to save us from going to have a look at them live. But I can tell you that just that folder on the USB, which became Exhibit 3, is simply an electronic version of all of the tweets referred to in this section.
We will now proceed with do you wish to rely upon your electronic version, or do you want to go through the hard copy so that we can place on record the evidence pertinent to the tweets of the 9th of July?
I'm happy to be guided by you, my lord, whether you'd prefer to look at them electronically or whether you'd prefer to go through my report. As I say, they mirror each other.
My lord, I will rely largely on the on the hard copy. It is easier to follow, and then when necessary, we will just refer to the electronics. Most of these videos or clips are what we've watched already, and I'm sure that we will be able to recognize them as we go along. But if there is one particularly that I wish the witness to refer to, then I will make reference to that and we can go to that. Will that be possible?
That's in order, my Lord. If Malenoshran can just make sure that any new ones are going to be introduced. But I agree there's no point in replaying those that we've seen many times.
I will, as we encounter one that we've not dealt with before, I will then refer to the electronics.
Yes,
the video was prepared on that basis so that we don't waste much time. Remember, starting at paragraph 719.
Yes.
Right. This is a place on record. What is in paragraph 719 as you've seen it?
So this was really where I focused my report. Is what happened on Twitter directly before, during, and after the violent unrest. Now, on the 9th of July was when the unrest really took hold in KZN. And if we start in chronological order, my lord, at 7:30 that morning, the accused tweeted a poster which said, "Until at President J.G. Zuma is free," capital letters, "safe," capital letters, "alive," capital letters, exclamation mark. "I agree with this." Amandla, fist pump emoji, fist pump emoji, fist pump emoji, 3 exclamation marks, hashtag free Jacob Zuma. 7.19 on page 25.
Yes, I'm there, but where are you reading?
I'm reading from the screenshot, my lord, which is a screenshot. That's the visual, which is what we would call the media. So in this case, an image of a poster calling for the shutdown of KwaZulu-Natal on the 9th of July, 2021. Government. But what I was just reading was the tweet attached to that media. So just above that image, my lord, where it says the name of the account, Duduzile Zuma-Sambudla, and the Twitter handle. So a handle is identified by the @ sign just before it. "Until President Zuma is free, safe, alive, I agree with this, Amandla. Hashtag free Jacob Zuma, Azisha."
Ma'am, just so that we are clear now, you mentioned media and you mentioned tweet. Right? I just want you to use this one as an example so that in future when you refer to media, we know exactly what you're talking about, and tweet what you're talking about. And please explain tweet in some greater detail as far as the posting of it is concerned and the authoring of it is concerned.
So, if we have a look at that screenshot, my lord, under 7.19, that is a screenshot which I captured using an app called Snipping Tool, and it shows the following things. Top left, there's a round image. That was the accused's profile picture at the time I captured this screenshot, which at the time was a Russian flag. Next to it in bold is the Twitter account name at Zuma-Sambudla, and just below that the Twitter handle at D Zuma-Sambudla. Then the writing just below that, so the writing in between the account name and the image, that's the part that we would call the tweet or the caption. until at President J.G. Zuma, so that at sign targets the account handle of the former President Jacob Zuma. So that also becomes a hyperlink, like a hashtag. You could click on it and it would take you to Jacob Zuma's account. So how this works, my lord, is that you can tweet anything. You are limited by a certain number of characters. It used to be 140 characters, but now, depending on what type of account you have on Twitter, you can go longer than that. And then I use the term media, my lord, because that is how it is referred to on the Twitter/X platform. So if you look at somebody's account, at the top you get tweets. It used to be your likes. Every like you've ever made was collated. Elon Musk did away with that. And then media. So any tweets you've posted which attach either an image or a video would constitute media. And so they're collated slightly differently. They do appear in the main Twitter feed, but if you're after media, you can just click on the media tab as well.
Council, we are interested in explanation because the issue of how I was hoping that we'll just focus on what is there, what does it mean, then she interpreted. Because we have several witnesses explaining same thing about, Twitter.
My lord, if the point has been established, I will not deal with it any further.
That's how, but I'm not curtailing you.
I understand, my lord. If the point has been established, and
it's clear from your two colleagues whether they agree with
if there's a clear understanding of what we are dealing with, I will.
Now it's clear to everybody.
My lord, I agree. This evidence has been led and it has never been disputed under cross-examination.
Indeed, my lord. I was guided by my lord's earlier question, but obviously I misunderstood it, and I will move on. Ma'am, thank you very much. I was just getting clarity on that, but it seems that everybody understands. Now,
good.
The tweet on the 7th, on the 9th of July, the first tweet that we are dealing with,
yes.
719, that was posted at 7:30, correct?
Yes, correct. So at 7:30 in the morning, this tweet was published. I've got a translation there of what Azisha Comrades, CDES is the usual abbreviation for Comrades on Twitter. Let's get it going, let's make it happen, let's go, let it be lit. Although the actual translation from Google Translate is to burn. 2 minutes later, at 7:32 on the 9th of July, the accused posted another tweet to her Twitter account. The tweet read, "Roads closed in Mpangeni, ... Amandla, 3 fist pump emojis, 3 exclamation marks." And the video attached is a 22-second video, which apparently shows, according to news reports, protesters forcing truck drivers in Mpangeni to block the road with their vehicles and then flee with the keys, bringing traffic on the N2 to Pongola to a standstill. 1 minute later, so this is the third tweet in 3 minutes, at 7:33 on the 9th of July, the accused posted, "Comrades in Diepkloof, we see you, Amandla," 3 exclamation marks, 3 fist pump emojis, 3 exclamation marks. According to replies to that tweet, the video footage attached to the tweet showed military personnel marching at a funeral at least a year prior to the July riots. I note that many Twitter users replied very quickly to the accused to alert her that the video had nothing to do with her father or the July unrest. Some observations was that there was no rain in Diepkloof that day. One person replied saying that this was my uncle's funeral in 2020. Now, I referred earlier, my lord, to 3 WhatsApp chats which were given to me by the DPCI for analysis for a separate memorandum where actual coordination of riots was taking place. And I thought it very important that shortly after this tweet was published by the accused, 37 minutes later, that same video was then circulated on a WhatsApp group called Free Zuma Coordinators, which was used to coordinate and orchestrate the July 2021 riots.
Ma'am, so far as you referred to those 3 WhatsApp groups, did you mention them earlier in your report?
I mentioned right at the beginning of my report, in paragraph 2.5 on page 2, a description of the chats that were handed to me.
Can you please just place, for the purpose of this case, the names on the record, just the names of the WhatsApp groups for now?
The 3 WhatsApp groups were called the Free Zuma Coordinators Group, the eThekwini Shutdown Group, and the Inc. Shutdown Group, Inc. standing for Ananda, Intuzuma, and Kwamashu.
Yes, ma'am, to go back to the current evidence, you said that a post by the accused was retweeted onto this account.
Not retweeted, my lord. What happened was that the video, which was shared by the accused at 7:33 on the 9th of July, very shortly afterwards, that same video was shared on the group amongst other instigators and coordinators.
I mean, just very briefly, without going into great detail, why are these 3 groups important in your analysis of the tweets in the accused's account?
So what was happening on those groups, my lord, was real orchestration of actual unrest. This is where we're meeting at this time. This is how you make a bomb out of home materials. This is the address of a particular politician. So real coordination, it was a group, these groups were at maximum capacity, a lot of people, a lot of content. And what I noticed and why I thought it relevant, although I was instructed to prepare 2 distinct memorandums and opinions, is the extent to which there was an interplay, a cross-pollination between content shared on the groups, which was then shared by the accused, and vice versa, content which was shared by the accused, which was then shared on these groups with the other instigators.
Proceed, ma'am. We are at paragraph 7.25.
7.25 is a screenshot of the video being shared on the Free Zuma Coordinators group. If we go to 7.26, that was the 4th tweet of the accused that morning. It was at 7:43, so in 13 minutes. The first one was at 7:30. There was a tweet from the accused which said, "Bring back Jacob Zuma, bringing back hope to South Africa. We want to see him walking down the streets Kumalo tomorrow," capital letters, 3 exclamation marks, hashtag Free Jacob Zuma. And there's a picture, the attached media is a photograph of Jacob Zuma, again with his hand raised in a fist pump, and it is stamped with text, "The Revolutionary."
Proceed, ma'am.
At 7:48, so I'm now on paragraph 7.27, the fifth tweet, where the tweet reads, "Comrades in Richards Bay, we see you!" Exclamation mark. Amandla, 3 emojis, 3 fist pump emojis, 3 exclamation mark, and then in brackets, "Who does sugar cane that is being burnt belong to?" There is a 25-second video attached to that tweet. May I presume that the court has seen that video?
We have seen the video previously, and I'm sure that if there are any questions, it will come from
Thank you. Paragraph 7.28 at 7:49. So we're now about 20 minutes after that first tweet. On the 9th of July 2021, 1 minute after the Richards Bay video was posted by the accused, that same video was circulated on the Free Zuma Coordinators WhatsApp group. Again, my lord, showing the interplay of content being tweeted by the accused and then being used by the instigators on the WhatsApp groups, which were being used to orchestrate the unrest.
Ma'am, again very briefly, as far as those 3 groups are concerned, are you able to tell us, in respect of your investigation, what was the outcome?
According to my investigation, I concluded that there was no question that there was very obvious organization, orchestration, incitement, coordination of public unrest and violence
In those 3 groups?
in all 3 of those WhatsApp groups.
And are you aware of any action taken against members of those groups?
I believe that there were a number of arrests, and I believe that case is ongoing.
Thank you, ma'am. Let's proceed with 729.
729 is a statistic from the South African Cane Growers Association, which reported that more than 500,000 tons of cane was burnt during that unrest, and over 130,000 tons of damaged cane was rejected by mills, resulting in lost revenue to sugarcane farmers of approximately 84 million rand.
Ma'am, that is information. Where did you obtain that information?
From the SA Cane Growers website in an official press release. It was a press release relating to how the 84 million rand in losses threatened rural sugarcane jobs. It's footnoted in, it's linked in footnote 15 at the bottom of page 31.
Thank you. Let's proceed to the next tweet. The particular purpose of this evidence is to deal with the tweets posted by the accused, right? And how they influenced you, eventually how they influenced your decision as to what had transpired, okay? I take note and obviously place on record all of the other, but the focus is on the tweets themselves.
Thank you.
Do we follow? Thank you, ma'am.
I do. At paragraph 7.30, at 7:57, so we're still dealing with the content that was posted in the first 30 minutes of the accused's posting for that day. The accused tweeted a picture of a person I believe to have been the governor of KwaZulu-Natal province at the time. The tweet is written in isiZulu. Again, it finishes with Amandla, 3 fist pumps, 3 exclamation marks, and hashtag Free Jacob Zuma. According to Google Translate, and I'm sure the court has better translation available, but according to Google Translate, which was available to me, the tweet means, what would it be like if we went to the office of the governor of KwaZulu-Natal province? Amandla, 3 exclamation marks, hashtag Free Jacob Zuma.
Ma'am, this was on the morning of the 9th of July at 7:57, correct?
Correct.
And I just want you to deal briefly with the distribution as far as you can of that tweet.
So that tweet was circulated later that day on the Free Zuma Coordinators WhatsApp group. That exact tweet, a screenshot of the tweet as it appeared. The evidence appears in my screenshot underneath paragraph 7.32. I didn't include a screenshot where people replied with the actual address on the WhatsApp group, which they did, the actual physical address of the person depicted. I left that out of my report in the same way that I left out my personal address.
Now, ma'am, I just want to focus on the retweeting or the sharing of the accused tweet by this group, Free Zuma Coordinators. Right? When it is shared by them, it will appear on their Twitter account, correct?
No. So we're dealing with two different platforms, my lord. The one is Twitter, now called X. The other is WhatsApp, which is owned by Meta. So the memorandum I prepared on the instigators coordinating using these WhatsApp groups, and there were 3 of them because they got very full very quickly. There's a limit as to how many people you can have on a WhatsApp group. At the moment, that limit is 1,024 people. That is when it reaches capacity. So when those groups were reaching capacity, they were starting new groups. On Twitter, if you retweet something, you press that button with the 2 arrows, it retweets that content on Twitter. You have to have a Twitter account in order to retweet something. What happened, my lord, was that a screenshot was taken of that exact tweet, which is depicted in paragraph 7.30, and the screenshot was shared as an image on the Free Zuma Coordinators WhatsApp group.
Now, just in fairness to the accused, would the accused have any control over who screenshots her tweets and posts them on other accounts?
No. Once you have created that content, it's out there. So, my lord, when I'm teaching children from as young as primary school, it's starting to teach the appreciation of the mantra, digital content is dangerous content. So if I post something, anybody in the world can take a screenshot of that, a screen record of it, use a secondary device to capture it, and that content is out of my control and can be circulated anywhere.
The answer is to the question. What is your answer to the question?
The answer to the question is no. She wouldn't know who has taken a screenshot.
Yes, proceed.
Proceed, ma'am.
I also have included in paragraph 7.33 that one of the participants on that Free Zuma WhatsApp group replied to that very same tweet, which was now screenshot and shared on the WhatsApp group, Agushe, which means with a fist pump of 4, 3 fire emojis, meaning it must burn.
Proceed, ma'am.
If we go to paragraph 7.34, we're now 32 minutes after the accused started tweeting for the day, and it's the 7th tweet of the day. The tweet reads, translation, : we want Inka Malala, I apologize for my click, It's nowhere, but I'm instructed it's President Zuma's clan name. We are not fighting with anyone. We just want at President Zuma, Pres JG Zuma, that's the Twitter handle, Amandla, 3 exclamation marks, 3 fist pump emojis, 3 exclamation marks, hashtag free Jacob Zuma. May I presume that that video, that media has been watched?
At this stage, yes. I think, if I recall, we have watched that.
Thank you. It is in the exhibit if anybody wants to access it later. The next tweet was at 8:09. The tweet reads, "This is a man who killed our people and never saw prison. Hashtag free Jacob Zuma." I'm not going through, my lord, the reach of each of these posts. They are available on the screenshot. As I described, the message, how many people retweeted it, how many people hearted it, and how many people bookmarked it or saved it for later access. The next paragraph at 8:21, the 9th tweet, Imga Baba, South Coast, ... we see you, Amandla, 3 exclamation marks, 3 fist pump emojis, 3 exclamation marks, hashtag free Jacob Zuma. And we see gridlock traffic on the road. So that was the 9th tweet of the hour. So in that first hour on the 9th of July, which was the day of the real unrest in KZN, the accused by that stage had tweeted, in my view, 9 different tweets which are relevant to this case. At 8:37, so I'm now at the top of page 36, the accused tweeted, "Early morning traffic report from Ananda, KZN, Amandla, 3 fist pumps, 3 exclamation marks, hashtag free Jacob Zuma." It's a 1 minute and 3 second video. At 9:12, the accused tweeted, "Comrades at Umgeni Road, ... we see you, 3 exclamation marks, Amandla, 3 fist pumps, 3 exclamation marks, hashtag free Jacob Zuma." An extract from the audio of the video. "It's just gone 7 o'clock. Umgeni Road has been severely affected as a result of protest action. You can see in the distance fires have been set by protesters who are also now starting to stone motor vehicles. Stay off Umgeni Road in both directions." And as I say, that video was accompanied by the tweet saying, "We see you, Amandla." I'd like to flag, my lord, that between my paragraph 7.39 and paragraph 7.40 is where chronologically the deleted tweet was tweeted by the accused. I'm not sure if you'd like to deal with that deleted tweet now or separately.
We will deal with the deleted tweet separately.
Thank
My
you.
Lord, if we just take note at this point, there was some time before 10:48 on the 9th of July.
At 9:23, according to the evidence available to me, the deleted tweet, which was the election poster tweet, which we'll discuss later. So it was just after the Umgeni Road tweet and just before the Harry Smith tweet. So I'll go straight to paragraph 7.40, which is what at 10:45 the accused tweeted, "Harry Smith, ... we see you, exclamation mark, Amandla, 3 fist pump emojis, 3 exclamation marks, hashtag free Jacob Zuma." The video attached to the tweet is one of the videos taken out of context. It's a video that was obtained on the 15th of June 2021, so approximately 3.5 weeks prior to the date in question. It was unrelated to the July riots. The footage of the 15th of June 2021 protest was published on Twitter, including by the Traffic South Africa Twitter account, and a screenshot of the original footage is pasted below. Again, we have an instance, as discussed earlier, of a misrepresentation where footage taken at a different time or different place is published to appear as if that unrest or violent action or celebration or whatever it shows is happening contemporaneously with the unrest and in real time with the tweet. At paragraph 7.42, 2 minutes later, at 10:50 on the 9th of July, the accused tweeted, "Imtuba Tuba, we see you!" Exclamation mark. Amandla, 3 exclamation marks. Sorry, 3 fist pump emojis, 3 exclamation marks. Hashtag Free Jacob Zuma.
7:42.
7:42, that's on page 38, my lord. This tweet elicited multiple responses that the video, which appeared to be real-time footage, was in fact historical footage from a King Shaka commemoration in Mtuba Tuba. Many tweeters noted that no one in the video is wearing a mask, despite it being during the COVID level 4 lockdown at the time. Many of the other videos you will see there are protesters wearing masks.
Sorry, I noticed that it's now nearly 10 to 4. This would be an appropriate time to stop the evidence. We will move on to what happened after 12 o'clock on the 9th of July, further tomorrow morning at 9.
So just to ensure that I interpret correct, I captured correct. The witness is saying this video.
My apologies, I can't hear you, my lord.
You are saying this video, into whatever video, where regiments running, you are saying it was a historic footage from a King Shaka commemoration. That's what you're saying.
That's what I say. And I obtained that from responses to the tweet and doing a reverse image search on the video.
Ma'am, whilst we have a few minutes, can you just very quickly tell us how a reverse image search works and how you utilized it in your analysis of the Twitter account?
So, my lord, a reverse image search is something that I believe all internet users should be able to do, particularly in this time of mis and disinformation. It allows you to take any image and search the internet for that image.
My lord, I'm sorry. The accused has indicated she wanted. Let's go, please. My lord, but the witness has asked if this video could be played.
Sorry, it's asked it?
If this video could be played, this particular one.
The witness will play. At 7:42.
Sorry?
7.
Yes, so it's
Super Spy. Yeah.
there we go.
Thank you, my lord. Assist the one of Amabuto. Thank you, my lord.
Yeah. Oh, sorry.
When I asked for clarity, you say you can agenda.
Indeed, yes.
I don't want to hold you long.
It's been a very long day, my lord. I at my age, I should not stand so long.
Well, you will have to come back tomorrow because we'll adjourn now tomorrow. What time? 9 o'clock.
9 o'clock, my lord.
9 o'clock is suitable to me.
You may stand up, Miss and your matter is adjourned to tomorrow at 9 o'clock. What will rise?
Guys, NPA owes me a massage. I don't care. I think